Welcome to the 2020 Virtual Spring Meeting, brought to you as a special edition of Our Curious Amalgam, the American Bar Association Antitrust Law Section's podcast. Virtual Springs Eternal, Friday, April 17th through Friday, May 1st, as we bring to you some of the top programs from the now canceled in-person spring meeting, as well as new hot off-the-press programs discussing the most compelling issues of the day. Be well and enjoy the show.
Hello and welcome to the Virtual Spring Meeting. My name is John Roberti. And today we're delighted to present another great panel, U.S. Privacy Law's Future, Pandemic Impacts. The panel is presented by the Privacy and Information Security Committee. And with me to provide some context is Gail Slater. Gail is Senior Vice President for Policy and Strategy at the Fox Networks. Hi, Gail.
Hi, John. Great to be here.
Well, it's great to have you. Gail, let's dive right into it. What is today's panel about?
That's a great question for a big topic, right? U.S. privacy law's future. And then on top of that, we layer this pandemic, which is also a huge topic in and of itself. So we're going to be talking primarily about legislative efforts already underway to craft federal privacy law that's comprehensive and sets a single baseline for the country, different from the regime we have today. And the only way I could cabin that huge topic is to say it's what it's not about, which is FTC enforcement actions, the so-called common law of privacy that we see coming out of the FTC in the form of enforcement actions and consent decrees and so on. So federal legislation.
And Gail, why is this important?
So this is an important topic for some time now. In fact, you could probably date the need for federal privacy legislation, the debate around it, back to the incipiency of the internet, which is 20 plus years ago now. And there's been various iterations on the need for privacy legislation at the federal level. I would say the most recent iteration began around 2018, and there were a couple of events that happened in 2018, the spring of 2018. I call them the privacy triple whammy. So cast your memory back if you can. I know we've got a lot to remember these days, but we had in the spring of 2018, we had GDPR coming into force in the EU. So that was thing number one. And that got the attention of lawmakers on Capitol Hill. Comprehensive privacy legislation in the EU, big overhaul there. The second was the Cambridge Analytica revelations that had to do with Facebook's use of and collection of data. And that led to a series of congressional hearings with Facebook CEO Mark Zuckerberg, and that put a real spotlight on federal privacy issues. And then the third, and probably the most important thing that happened in 2018 was California passed at the state level the first comprehensive privacy legislation in the country. And so that started a ripple effect. And other states are looking to pass their own privacy legislation. And so that's created demand for a serious look at comprehensive privacy legislation at the federal level. So these three events happened in 2018, but let's fast forward to today, and we're living in the era of COVID-19. And of course, COVID-19 has led to mass-scale collection use of big data to fight the pandemic, which of course is a good thing. But it brings with that concerns around how that data is being used, in particular because there's a lot of sensitive data being aggregated and used. And so that's sort of reignited the privacy debate that was already out there since 2018. So a very important topic at an important time.
And what are we hoping to learn from today's panel?
So listen, we have a great panel of privacy pros to talk to us today about this federal legislative push. And some of them are longtime FTC hands. And of course, the FTC is the nation's primary enforcer of privacy at the federal level. And so I'm really looking forward to hearing what this panel has to say about the need for privacy legislation. I'm guessing they're going to say that we still need privacy legislation, same as we did in 2018. And what should be in there, in particular as it relates to these very new and fast-moving issues that the pandemic is giving rise to.
All right, Gail, I agree with you. It's going to be a great panel. Will you stick around with me and we can listen to the panel and then come back and we can talk about some of your takeaways?
You bet. Thank you.
All right, great. Well, then let's send it over to the moderator, Chris Olson. Chris, take it away.
Thanks, John. Very pleased to be able to present this panel on the future of U.S. privacy law and how that future may be shaped or impacted by the pandemic. This is an incredibly timely discussion, as I'm sure all our listeners understand. This issue is in the news virtually every day. The Senate Commerce Committee has already had a paper hearing on enlisting big data to fight coronavirus. There will likely be more hearings down the road. And the focus is on how technology, how big data can be used for public health considerations to fight the pandemic. And of course, that presents very sensitive privacy concerns. And so we're very fortunate to have probably the best panelists we could have on this issue today. We'll start with Maneesha MITHAL. She's the head of the privacy division at the Federal Trade Commission and has been the head for many years, really at the center of the FTC's ever increasing focus on consumer privacy. Also joined by Jessica Rich, whose privacy roots go way, way back, maybe farther than everyone else on the panel. She is viewed as one of the key architects of the Federal Trade Commission's privacy program beginning in the late 90s, was the head of the privacy division and former director of the Bureau of Consumer Protection, and is now a distinguished fellow at the Georgetown Institute for Technology Law and Policy. Alison Pepper is also on the panel, Senior VP of Government Relations at the 4A's, American Association of Advertising Agencies, former Senior Director of Public Policy at the Interactive Advertising Bureau, many years of experience in policy work on technology and privacy issues. And last but not least, of course, Lee Tien, Senior Staff Attorney and Adams Chair for Internet Rights at the Electronic Frontier Foundation, also with many, many years of experience in privacy law and the intersection of privacy technology and free speech, and very active in policy issues in California and at the federal level. And we'll cover that. So let's get started. I'm going to kick us off with a few questions, and hopefully we'll have a very interactive dialogue today. But I want to start with Jessica, because I've read a few articles about how the current crisis, the pandemic that is occurring, has parallels to what happened back in 9/11. And I do recall that there was a lot of momentum for privacy legislation and privacy protections being enhanced in the late 90s, early 2000s. Obviously, 9/11 changed a lot of things in this country and had an impact on privacy protections. Similar debate, I think, to one we're hearing today. You were on the ground in privacy space in the 90s and in 2000s. Are there any lessons to be learned, Jessica? Are there parallels with what we saw then and what we're seeing now?
Well, in some ways it's similar, and in some ways it's different. So obviously, I assume we're focusing on the commercial side here, but it's worth mentioning that there were huge developments after 9/11 on the government side, with the government collecting data. And we still have the Patriot Act and other measures in place that were passed at that time that provide for greater collection of information. But focusing on commercial privacy, which I think is more the focus of this panel, one difference is that when 9/11 happened, we had already had a political shift, an election. And at that time, more than now, there were clear differences between Republicans and Democrats, with Democrats pushing, prior to 9/11, pushing for privacy legislation and Republicans generally opposing it. So amidst the crisis of 9/11 and the desire to collect information was also that political shift. So we did see an abandonment of the legislative push, but it hadn't been as forceful as now, the legislative push. It was more controversial at the time. And we did see a shift in priorities within privacy, but we didn't see privacy go away. And I don't think we're going to see that now. So back then, we saw a shift from the notice and choice model to a harm-based model, which is only take action against privacy if there are clear harms that are tangible, move away from notice and choice. And this narrowed the idea of privacy harm to the most pernicious types of harm. We did see a corresponding shift away from privacy and towards data security, because that was consistent with the harm model and it was aligned with business interests. But that actually strengthened privacy. It was a good development. It was a shift in focus, but it was not a shift away from privacy. It was a shift within privacy. We saw a greater use, ironically, a greater use at the FTC of unfairness as opposed to just deception because of the emphasis on harm. So there were some benefits there. We brought some very innovative cases at the time, again, due to that shift in emphasis, but not away from privacy. And I guess I would say the lessons are privacy concerns never went away. In fact, they came back with full force when the crisis had passed, even stronger because of the developments in the marketplace. And I guess the other lesson is, are there shifts in emphasis, even if the impetus for privacy legislation may be diminished? Are there comparable shifts in emphasis where we can still build privacy that's consistent with the current crisis in the same way that post 9/11 we focused on data security and less on privacy per se?
So do you mind if I jump in here and express a somewhat different perspective?
Absolutely, Lee. Why don't you do that? That's great.
Sure. I am an old fart, so I was around as well in the days of the, ATA, the MATA, and eventually the Patriot Act. And I think that one of the things that struck me about the difference between then and now is that, in both cases, we saw some level of increased private sector involvement in screening, in addressing what was perceived to be the threat. But because it was national security, we were not able to see the full extent to which companies and the government were cooperating. So, for instance, at EFF, as an outsider, we were able to see anecdotal evidence of companies offering databases of possibly suspicious people from their, corporate databases, which they had not previously been as eager to provide. But that was really the tip of the iceberg, right? Because as we discovered, or as we suspected, but then Edward Snowden confirmed, there was an enormous amount of assistance being given, or private public sort of partnerships with respect to both the 702 PRISM programs, where there was a lot of just processing of content data by the companies, along with the 215 programs having to do with call detail records. And we did not really know about this, or we suspected, but there was no confirmation of it protected by national security doctrines like the state secrets privilege. So it was very difficult from a privacy perspective to actually address those sorts of transfers. Today, we're seeing, because this is not it is a national security crisis, but the amount of sort of felt need to cloak things in the Foreign Intelligence Surveillance Act or anything. Instead, we have these relatively open public actions regarding public health and isolation, et cetera. And we also see a lot of companies quickly standing up and raising their hands and saying, hey, we will help with our cool tech to help the government collect data, or we're going to help, and this is, I think, more insidious, we're going to help people, whether it's something like the Project Verily screening site to direct people to, COVID-19 testing, but it's a partnership of private companies like Verily and Alphabet, along with a lot of other private companies and California public health agencies. So in that sort of a situation, it's very unclear, especially in an emergency. What are the true data flows? Who's getting this data? And when they are allied with public health, it puts a veneer, at least, of, this is the public interest. It's not being captured necessarily for any kind of private purpose. But we don't actually know that if we don't understand what kinds of agreements there are or what paper is in the MOU. So that's one of the differences I see between then and now. From my perspective, I'll say it's a more brazen approach. At this point, the companies are willing to talk about how much they're going to help with contact tracing and measuring location data, or various other kinds of proximity tracking. And this is all very, very much out in the open, and that feels very different from what we saw before. And the last point I want to make is, I think the similarity between now and 9/11 is a fear that there will be institutionalization of practices, of relationships that were provoked or stimulated or triggered by the crisis originally, and justified on an emergency basis, but may well linger. I mean, in past pandemics, we did not have big data companies capable of capturing and storing forever and then transferring to government all the data that was being generated as a result of the epidemic. And so in some sense, you could imagine that these emergency measures were very draconian privacy-wise at the time, but could have less of a future, because we would forget this quickly. Whereas now, the expectation, the default belief has to be the opposite, that everything that is being measured or tracked at this time will be kept forever and used forever, unless we specifically take precautions against it. So that's how I see these two periods of contract.
That's great, Lee. And just to sort of encapsulate what you guys have said, it sounds to me like the view is privacy is definitely not going away. It will remain post-pandemic. It is a very important public interest, that public value that's not going to disappear just because we have a strong need for data in the short term. Another difference is the data uses may be more transparent today than they were post 9/11. And then the nature of technology means the risk of mission creep or ongoing uses of data that are privacy invasive may linger, and that's a difference from 9/11. Maneesha, I think you wanted to jump in and would love to hear your perspective.
Yeah, so I had a couple of reactions to what's been said so far, and I think I agree with everything that's been said, but I want to make a couple of points. I think the first is that often privacy legislation is pitted against public health and public safety issues, but I don't think it has to be that way. And so I think that privacy legislation isn't necessarily about restricting uses. It's also about promoting responsible uses of data. And so we've seen some commentary that in the European context, because there's this concept of legitimate interest, that there may be fewer barriers to sharing information for public health purposes than there may be where we have a system in the United States with a patchwork of laws. So I've just heard that perspective, which I wanted to share. And then the other point I wanted to make is that I think just picking up of what Jessica said about moving from the notice and choice model to the harm-based model, I think thinking about privacy in a pandemic also points out some of the limitations of notice and choice and the importance of things like use limitation. As Lee mentioned, the need to delete the data after the pandemic is over. And so I think those are things that I think today's pandemic emphasizes some of the reasons why we've shifted approaches in the privacy space.
Chris, can I just jump in and pull together a few strands that I think all of us have been moving towards, which is that privacy is not, can be quite consistent with use of data during a pandemic. And so the things we ought to be thinking of, and we are more sophisticated than we were since 9/11 due to for many of the reasons Lee described, we ought to be thinking about that. Can the data be de-identified? Is consent possible? MIT recently is experimenting with a data collection model with consent, which if you provide the proper assurances about how the data will be used and reused, you're more likely to get. The issue of reuse is huge. Is the data just going to be used for the purpose of responding to an emergency, and will it be deleted when it's no longer needed? Is there transparency around the data use? And then, of course, we've probably partly since 9/11, many of the laws on the books today actually provide for various emergency uses with various conditions. They're not tight enough. They're not, as clear as they ought to be. But I did look up some of the sectoral laws, and they provide for emergency use, but they say things like in HIPAA, like only for the purpose of dealing with the emergency. So those are just some obvious precautions that we know can be taken, often consistent with using the data for emergency purposes.
Great, that's a great point. I want to bring Alison in here to speak on behalf of herself and her members. I will make one point, Jessica, to the point you made about privacy being consistent. Privacy legislation being consistent with use of data for other purposes. They both can go hand in hand. There may be challenges to that notion when legislation is passed in a 48-hour period and it's 850 pages. It's difficult to make sure the balance is drawn carefully and precisely in that sort of environment. And we can talk about that in a minute. But Alison, you've got a lot of members, small business enterprises, your industry has been hit really hard. What's your perspective? What are you hearing from your members, and what's your perspective on this privacy debate, privacy in big data use for beneficial purposes?
Yeah, Chris, it's a little bit ironic because this is the in my 15 plus years in this space, the past 3 weeks have been the past 3 weeks that I have devoted the least to privacy than I have, I think, in my entire 15-year career. And it's for the reasons you just mentioned. I mean, I represent probably 400 advertising agencies that would qualify as small businesses. And not surprisingly, the past 3 weeks has been very much about the CARES Act and the relief that Congress is trying to afford small businesses under the Payment Protection Program Act. Payment Protection Program. So I have probably spent more time talking to the SBA than I have to other entities over the past 3 weeks, but that's an anomaly. Privacy is an overarching 20,000-foot issue, is enormously important to my members. I would focus on my small members first and foremost to say that for the small members, and particularly my small members, they haven't made investments in their own data stacks. They don't own their own technology. They partner with entities to the extent that they use technologies for creating and delivering their advertising campaigns. One of the things that particularly the small entities have really struggled with, I would say, post CCPA, before, after, et cetera, one of the things that the small entities have really struggled with as the name implies, agencies are fundamentally intermediaries, right? They don't have frequently that direct one-to-one consumer touch point that, say, a publisher might have, or a brand might have, or a media property might have. So for companies like mine, the agencies who are those intermediary properties, they have expended enormous amounts of time and money trying to understand what a lot of the privacy legislation means to them as intermediaries, right? So for the folks in between, there is not a lot of clear guidance when you don't have that end-to-end consumer touch point as to what exactly you're supposed to be doing to comply. And I think that's one of the biggest things I've seen, because you have to remember, these small agencies, they are in fact small businesses. They don't have in-house counsel, right? They don't have in-house technologists. They don't have endless amounts of money to pay retainers or project work to outside counsel to help them, right? And particularly now, when, not unlike a lot of other small businesses, their budgets are being decimated. They're in survival mode. This is going to be even harder for them going forward. So I feel like that point of view occasionally does get lost in this conversation. We assume everyone brings to bear the resources of a 3,000 person agency or a 3,000 person tech company. A lot of my members don't have those resources. To the extent there's lack of clarity in privacy legislation, they struggle with what compliance means.
That's a great point, Alison. Tech is not just one big monolith. There are large tech companies and small tech companies, and the interests of each often diverge. Lee, I think you wanted to make one additional point on the difference between the 9/11 era and today, and I would ask you, as you make that point, to also weigh in on the issue that came up earlier, which is the fact that the CARES Act was released in about 48 hours. I know CDC was authorized to create a surveillance database with analytics. What is the opportunity that EFF and any other group has to affect any change or modification in legislation that's passed in a 2-day period?
So I'll answer that big question first, which is it's very hard. And this is actually something that we're seeing at the state level as well. Here in California, for instance, but also in states like New York, the most of the legislative process is being dominated by budgetary considerations. And in many state legislatures, such as California, the way the budget is done very differently than other kinds of legislation. So, for instance, we EFF, we lobby in Sacramento. We work on a lot of bills. We don't generally do budget stuff. At this time, we're actually having to shift our approach, our focus away from policy committees and towards the budgetary and appropriations process, which is far less transparent. And those of you who have dealt with budgetary bills on the Hill understand just how much can be hidden in little tiny mouse holes all over the place. And you need appropriators like on the Hill, right, to actually be understanding what's going on with that. And so there's a lack of visibility and an inability to really vet anything. If you're an advocate, access becomes really, really important. The larger, and maybe it's not larger, but I think it's an important difference between now and then that needs to be considered, is that 9/11 was very federal, right? The main actors were actors in the federal government, whereas, and it was out of the IC or DHS, which didn't exist yet, but those kinds of homeland security functions, which tended to be centralized in DC. Contrast that with today, where we have, seen a relatively great disparity between the what's happened at the federal level and what must be done at the local or state level. And so that means that from the standpoint of those who are trying to influence what's going on, it's a lot harder to sort of focus on 50 different jurisdictions, or even the transparency of actions taken at the city of Berkeley level or city of San Francisco level compared to what's happening elsewhere. And so even in a for a group like us, it's just a lot more. There's a lot more chaos in terms of what is actually happening. So you can imagine that this city puts in this sort of ordinance that affects civil liberties in a certain way, and another city does something else, and you don't have, there is one entity that's doing something, and then you can say advocate against it. Instead, it's just like happening everywhere. It's happening chaotically, and unlike, say, terrorists and folks who are traveling across the borders, it's all consumers. Every one of us is sort of a potential target of civil liberties issues here, whereas, it was a much more restricted domain in 9/11. So as a practical matter, for folks who are trying to influence or understand what is going on, it's just a very, very sort of different, you're just looking at a much bigger, wider, and messier terrain right now.
That makes perfect sense, Lee. I appreciate that. Maneesha, I think you wanted to add a point to this, and I would also ask you, where's the FTC now as the pandemic issues intersect with privacy issues? I'm certain the FTC is focused on priorities that may implicate some of the issues of today, and would love to hear you talk about that.
Sure, Chris, thanks. I'd like to talk about that. Before I get to that, I wanted to pick up off a point that Jessica made and Alison made, just talking about some of the limitations of consent. I think consent is an important piece of the pie, but I think both because we have several intermediaries that don't interface with consumers, and the fact that it's difficult for consumers to understand nuances. I think Jessica brought up the example of the MIT researchers that are coming up with a consent-based tool on contact tracing. But I think the other thing they're doing is they're trying to figure out ways to implement privacy by design into this technology. So, for example, they're not using the more invasive real-time geolocation GPS tracking, but they're using technologies like Bluetooth, which are less privacy invasive in this context. So I think those are really interesting developments. Now, turning to the FTC, our work has certainly changed over the last 30 days or so. And let me just mention 3 areas where we're getting a lot of questions and that we've done some things. So the first is in the area of video conferencing. I think as everybody can appreciate during this pandemic, we're all being connected by video conferencing. We've gotten some questions from senators about what we're doing on the subject. We've gotten requests to start investigating companies like Zoom, which of course I can't talk about. But what I can say is that people are using video conferencing for very sensitive purposes. Telemedicine, where they're sharing sensitive medical information. EdTech, where information about kids is being shared. And so this is a really important area for us. And so just on the EdTech issue, this morning we issued both a business education piece for EdTech providers as well as schools, and a parent education piece where we talk to both audiences about things that they might do in the EdTech space. Now, one of the things we make clear to businesses is that COPPA, the Children's Online Privacy Protection Act, is not a barrier to providing robust EdTech services. And we do say that companies can get consent through the schools instead of parental consent. So video conferencing is really the first big area. The second area where we're seeing a lot of action these days is in the area of artificial intelligence. And so you see a lot of algorithms and models being built or ideas being had about things like, and I saw this in Ryan Kalo's paper in preparation for the Hill hearing. He talked about the idea of using connected thermometers to figure out locations where we need to move COVID resources. Well, given the price of digital thermometers, that kind of initiative would run the risk of disproportionately helping people in wealthier areas than in less wealthy areas. And so one of the things we did yesterday was we put out a blog post from our bureau director, Andrew Smith, talking about responsible uses of AI and asking companies to ask themselves questions when it comes to using or unveiling AI products. And then the third area that I just wanted to mention, very related, is in the area of connected health apps. Now, one of the things that HHS had done earlier this year was it has required interoperability between doctors' offices and health apps of consumers' choice so that they can port their data from app to app. Now, this is going to have implications during the pandemic as well. And I think there have been some concerns about the fact that this data may not be covered by HIPAA, but at the same time, it is covered by the FTC Act. And so we are looking at these areas very closely. And my third point is that on connected health apps, that is an area where we're getting a lot of questions. The Department of Health and Human Services recently issued some guidelines requiring interoperability between doctors' offices and the health apps of consumers' choices. And one of the concerns with consumers being able to port all their health data is that HIPAA will no longer apply. But the FTC Act does apply. And so we're going to be looking at areas where we can look at these apps. And to the extent that any of them are engaged in unfair, deceptive practices, we're going to be taking a close look at that.
That's great. That's great. Jessica, did you want to jump in on an earlier issue here?
Yes, I wanted to just add to what we'd said about some of the changes brought about by the current environment and pandemic. So I think it's really affected everyone's posture towards the platforms. Towards the large platforms, one of the driving forces in the push to legislation and concerns about privacy was the dominance of the platforms and their ability to use large amounts of data and their competitive advantages in the marketplace, which many people felt was unfair. Well, now small businesses are increasingly unable to function, and some sadly will go out of business. And now many government entities and others are looking to the platforms to help deal with the pandemic. So everything in terms of the platforms has been turned on its head. The platforms may end up with even greater advantages in the marketplace if they have even less competition from small business and even greater dominance. And they're being looked at as the saviors as they help develop these platforms for health. So that has very much changed the dynamic and in many ways that are actually quite concerning. So just wanted to add that in.
Yeah, Jessica, that's an excellent point. I actually had on my list to go over, what about the techlash and the different opinions that people are voicing now about that concept? Has that been flipped? And I think your perspective is a great one. Alison, I'm going to ask you if you've got a perspective on that, but also if you have a perspective on whether the current crisis provides more support for a federal privacy law than existed previously, and whether that's more likely now than perhaps it was earlier.
Yeah, Chris, and I'll address both of those. And my power just started flickering on and off. So if you lose me, maybe my answer wasn't meant to be. On the first one, to follow on Jessica's point, I think that's really interesting. I was thinking about this the other day. From 9/11 to where we are today, and I just for perspective, I was in my first semester of my first year of law school when 9/11 happened, right? And what I saw over the next 2.5 years of law school was an explosion in brand new classes having to do with the government, the privacy, and you, right? And what it meant. And it felt like in the aftermath of 9/11, the conversation was all about government and privacy, right? Government's intrusion in privacy, government's ability to track you surreptitiously, surveillance on a wide scale, government, right? And I think what's interesting is what we're seeing in, this first early month of this pandemic. It doesn't seem to be so much about people saying, I don't want the CDC, I don't want the NIH, I don't want the National Academy of Sciences to have my information. I'm not sure I want Google to have it, right? Which is almost an interesting flip of I'm not so much concerned about government, I'm more concerned about these private entities, right? And even the early days, the sort of privacy is no doubt in the collective consciousness, I think, of the average person in a way that it wasn't, what we're seeing with Zoom and some of the geo-tracking. But it's interesting, it seems that people's first concerns around privacy aren't government, they're private entities, right? Which seems very different from what we saw 19 years ago. So it's been an interesting evolution of where the national consciousness is on that issue. And then your second question, I think, was around whether or not what's going on right now makes more of a case for a federal privacy standard. Second one. Yeah, the federal privacy standard is something that my organization, the 4As, and many other organizations have been working on and asking for years. We've been working on an initiative called Privacy for America, looking to craft federal privacy legislation. I think there was a lot going on with federal privacy legislation before, the pandemic kind of took center stage and absolutely everything going on for obvious reasons. But one of the interesting things I think that's come out of it is pandemics are no respecters of state lines, right? Unfortunately, fortunate truth we've seen over the past couple months. They're no respecter of global boundaries. They're no respecter of state boundaries. I think when we start thinking about, whether this is, fingers crossed, hopefully not our future of, health crises in this area, I think what's going on makes a bit of a stronger case that we have to consider privacy as a comprehensive federal issue that crosses state lines and has to be addressed at a broad issue, not as something that starts and stops at state boundaries. Because the ability to track for these, whether it's in partnership with governments and however it's working, if that has to be respected or done at a state by state, 50 states plus territory lines, it's going to be harder for us to get a national comprehensive picture on what we need to look at for things like heat maps and infection origination points, et cetera. So if anything, I think I don't want to overblow it. I don't want to oversell what I think this might mean to privacy. There's a little bit too much opportunism sometimes with a crisis, so you don't want to go too far with that. But I do think there are legitimately aspects of this that show there are times when a singular, comprehensive federal approach does work better.
So,
making the case is very different from whether Congress will actually move forward and do it. So, Alison was talking about the principles.
Absolutely, guys. And I do think, whether there's additional support as a result of the pandemic is one question. Jessica, to your point, whether ultimately legislation can get through Congress is a totally different animal. Lee, I think you had some comments on the dialogue that's come before, and happy to have you jump in.
Great, thanks. First to that immediate point about national privacy legislation. I think that the thing that's funny about that is when you look at this crisis and you look at where, again, my federal versus state point, the locus of action, we don't have much in the way of federal public health emergency power, right? These are primarily, we have the power, but under our federalist system, the police power, which is the constitutional source for a great deal of quarantine and public health emergency power, is actually more reserved to the states. And so currently, just as we have a patchwork of privacy laws, we have a patchwork of public health emergency laws, though they vary from city to city, from state to state. And so when we think about the potential for a crisis like this to stimulate sort of centralized national legislation, it seems to me that at least for these kinds of problems, we're almost putting the cart behind the horse or in front of the horse. I'm not sure about that metaphor, to think about the privacy aspect before we think about the actual locus of power for dealing with the problem in the first place. And because those different kinds of statutes or ordinances offer different powers to the municipalities or counties or states to collect information in the first place, and so much discretion to enter into agreements with private entities, then the problem gets the problem that I've been talking about in terms of, wait a minute, how do I know where my data is going? What is the data flow? Who gets to keep what for how long? Who has access to it? Those are all secondary to the acquisition and collection of the data in the first place. So it seems to me logically you have to think about those first. And then with respect to some of the things that others have talked about, I want to emphasize that, we talk about the privacy versus the non-privacy aspects of things, but we can't ignore efficacy, right? One of the things that we really worry about in the tech world is sort of a techno seduction. That is, we're always looking for the right tool or the best way to do something, and people nerd away at these things. But, in a situation where we don't have testing, where we don't reliably know what are the rates of infection, we don't know what the percentage of asymptomatic carriers is, a lot of both the contact tracing and the proximity tracking that people are talking about, at the end of the day, what matters is whether or not if the information they are giving you is not correct, even if you tested negative today, you might test positive tomorrow. How much confidence do you have in a test? How many the percentage of people who have been tested is tiny in this country relative to how many people we have. And so the error and their error rates and the false negative or false positive rates surrounding the data that's being used for either contact tracing or proximity tracking is really in a great deal of dispute. And I wanted to distinguish between those two terms, contact tracing and proximity tracking. I think a lot of people think, first of all, about using GPS or cell site location information or Wi-Fi triangulation. But these are intermediated, right? Whereas the stuff in Singapore that people have been talking about, these proximity tracking techniques using Bluetooth, what's significant about the differences between them is that Bluetooth is a peer-to-peer protocol that does not necessarily require any kind of centralized database of location. So instead of saying, we're going to figure out where Alice is and where Bob is, and then see how close Alice and Bob are, and all of that is data that's sort of intermediated because some entity actually is figuring that out. Bluetooth is more like, I am a bubble and you are a bubble, and these two things when the bubbles contact, then there is a track, and that has those two different things. One is centralized and one is peer-to-peer, have very, very different basic privacy implications. Right now, you still could store the Bluetooth interactions in a centralized database, and that would defeat the the sort of the privacy by design aspect of Bluetooth. But I just wanted to focus to make sure that people understood that not all of these protocols for trying to determine how close people are to each other have the same basic privacy principles.
Yeah, that's helpful, Lee. And I think a number of witnesses at the Senate Commerce Committee hearing flagged one of the issues you just talked about, which is, we need to be mindful of how accurate the data is in order to understand the appropriate uses of that data. And I think there is a desire to lean into as much data use as we can. And there may be folks who aren't paying close enough attention to whether conclusions drawn from that data are well-founded. I wanted to pivot just for a second to key off a point Alison raised and come back to an issue Jessica raised at the outset, which is the linkage between government access and commercial privacy, because there is a linkage that came out of 9/11 and national security that is evidenced in the Privacy Shield. So the Privacy Shield is a data transfer mechanism that allows U.S. companies to collect data from EU citizens if they're members of the Shield and comply with the principles laid out there. One of the concerns Europe has always had with the Privacy Shield is government has too much access to consumer data, and therefore they have concerns about the ability of companies commercially to use EU citizen data because it may get into the hands of government. And that raises a question of how analogous we are today. Alison, you said people are more concerned about the big platforms getting access to data than they are government. Is that going to be the same issue in the EU with their different historical backdrop? The EU has always, I think, been more suspect of government access to data. And will the changes that we're making now, if we assume that there's going to be more government access to data for public health purposes, will the EU look at those government access opportunities and be concerned about data transfer issues to the US? Very long-winded question, but I'm sure Jessica and Maneesha, I'm sure everyone has something to say about this. So Jessica first.
Well, before getting into how the EU might react, I think backing up to identify what the real issue is, I think the real issue is that when information goes back and forth, whether it's between private sector and government or government entity and other government entity, et cetera, there are not sufficient controls in current laws or norms about how that information can be reused. So if government gets access to commercial data, there aren't, then are there limits on how that data can be further used? Can one government agency, if you give it for emergency purposes, is it going to end up at the IRS or some other government agency or on a terrorism watch list, with erroneous data? So I think that one of the things that needs to be done, regardless of where the data is flowing, is that when data is flowing for emergency purposes, there have to be guardrails around it, cordoning off its reuse. And consistent with that, we should be looking, as we look ahead to a healthy privacy regime would be one that provides for emergency use with guardrails and doesn't suddenly get thrown out because there's an emergency. We should be building a concept for privacy that contemplates there may be emergencies and provides for that with sufficient guardrails.
Okay, that's an excellent point. Maneesha, you wanted to jump in?
Yeah, if I could just make 2 quick points unrelated. I think the first is I was reading something, I think it was from somebody at the UN, and I was struck by how he talked about how privacy laws talk about misuse of consumer data. But I think in addition to misuse, we need to think about misuse. And so that's just a fancy way of saying that, we need to balance the responsible uses of data with kind of data protections and making sure it's proportional, deleted afterwards, restricted by use, et cetera. So that's the first point. The second point I wanted to make, just in response to your question about whether we're going to be in the same situation with health data that we are in national security, I think time will tell on that. I don't know where we're going to end up. I don't know if the Europeans will have an issue, say, under Privacy Shield for excessive use of data for emergencies. But I do think in reading tea leaves, it's interesting. I know that IPP has put out summaries of what the various DPAs have said about use of data during this crisis. And if you look at some of the summaries that have been made, they talk about some member states that have been quite permissive in the use of data for emergency purposes. Others have been quite restrictive. And so I don't think you see that same uniformity of opposition to national security in this public health space.
Yeah, that's a great point, Maneesha. So Lee, I think you wanted to jump in on another issue here, so fire away.
Yeah, no, thanks a lot. Maneesha had earlier mentioned how the commission is offering guidance to people on teleconferencing software. And I wanted to talk about that a little in the context of Zoom, because at EFF, we have a pretty active sort of like hotline intake. People are always emailing us or calling us about questions they have about whether or not their privacy is at risk. And we have received quite a few, I would call them complaints or concerns about how schools are handling remote learning and other kinds of remote distancing software. And the thing that I wanted to emphasize was not to dump on Zoom so much, because yes, they have definitely gotten some PR hits on over Zoom bombing and other issues. But what I wanted to talk about was it's not just Zoom that we are hearing about. We are hearing about, say, college boards and various kinds of requirements that students install particular software programs in order to, say, like for proctoring. And what we're seeing is then folks will go, well, is this safe? You're requiring me in order to go to school and to do stuff or to take tests and apply for college to install this remote proctoring software, lockdown, or something like that. It doesn't actually matter which product it is. What we get is a lot of questions about what is this doing? Is this malware? They will not tell us what information this processes or captures when it's on my device. And this is not just school issued devices, right? This is, you can use your own computer, but if you want to take a test on it, you have to have this stuff on it. So what I'm sort of pointing to is we don't know how the data flows in these programs work. We don't know what kinds of arrangements that that these companies that are actually vending these programs are up to in terms of data. And there's no transparency for the students who are being essentially forced to install it. They're not getting any kind of meaningful information from their schools or their school district or anything about why this is not a security or a privacy risk. And so I think that really highlights in this time we're all depending on a lot more technology, and yet there is no basic preparedness infrastructure within, say, public schools to even vet that stuff. And that what worries me about that, and I'm going to tie that into the concerns about how the techlash is reversing. You see a small company like Zoom, it gets some bad publicity. And the next thing you know, the New York Department of Education is saying, nobody can use Zoom anymore. You all have to use Microsoft Teams. That's what's happened in New York City. And I'm going, so did you guys thinking to myself, did you do a security analysis on Microsoft Teams? Or are you just making this decision because you heard that Zoom had bad publicity, there's Zoom bombing, and therefore we're going to just run to something else that we also haven't vetted? And this is particularly concerning because we know that, say, Microsoft and this is not so much to blame Microsoft, but just state of fact, they contributed a lot of software, a lot of programming, a lot of help to the city of New York in the years since 9/11. Lots of, predictive policing, big data mining and stuff. And I would be I'm going, so is Microsoft Teams just a convenient choice because everybody's already got it? Or is this more like, well, you should have had a procurement process that was fair or that was open so that other people could compete, as opposed to we're just in a time of crisis making some quick choices that are convenient and therefore sort of help are basically part of the existing sort of lack of competition in these kinds of marketplaces. So I'm I'm concerned that those kinds of effects, which are, analogous to what folks were talking about before in terms of, maybe this will increase concentration, maybe this will improve the state of the large tech platforms relative to the small upstarts. These are all things that I think are happening in this space right now.
Yeah, that's a great point, Lee. And one thing that prompts me to think about is there are going to be a lot of lessons learned here once we get on the other side of this pandemic, and hopefully that will be sooner rather than later. Sounds like it's a great opportunity for an FTC workshop examining a number of these issues that have come up in the middle of this crisis, and what lessons we have learned and how we might be able to move forward in a different way the next time this rolls around. But I wanted to ask everyone one last question. You guys have been great. It's been a very entertaining and interactive panel. I think it's safe to assume that privacy legislation at the federal level, maybe even at the state level, is not going to happen in 2020 with everything that's happening right now. But let's look ahead to 2021. There's been a huge amount of momentum for privacy legislation at the state and federal level up until the time of the pandemic. What do we foresee in 2021? And Alison, to your point, there may be stronger support now with what's happening in the pandemic than there was previously. I'll start with Jessica, and then go around to the rest of the group.
Well, I agree that there was this confluence of circumstances, magical, in 2019 that is gone. The state momentum, GDPR, the Facebook, Cambridge Analytica, the focus in Congress, the hostility to the platforms, as I discussed, the Experian breach, blah, blah, blah. But privacy does not go away. And assuming things come back, the pandemic, I wouldn't say ends, but, it is under control and the economy gets back. I think that privacy is coming back around just as it always does. Privacy does not go away. It never has. And I expect there to be action in 2021 on privacy.
Great. How about you, Alison?
Yeah, I would essentially agree with what Jessica just said. Between governments, whether it's, federal, state, local governments, dealing with not just the immediate crisis of the pandemic, but then dealing with the economic repercussions that are going to be with us for a long time. I think that's going to be just front and center, as it really should be for government for the time being. Also, with an election year coming up in November, I think that's going to have an impact on where we see federally going into 2021, who we have in the White House, maybe even the Senate, right? That's going to have a good impact on what we see going forward. So some big variables in terms of where we are with an administration and where we are with Congress. But circle back to my point I kind of made in the beginning, I do think the collective consciousness and awareness of privacy issues really has become front and center in a way that those of us in this business would have anticipated, but maybe those of us outside this business might not have anticipated. And that some of the big stories we've seen coming out of this pandemic early on are around privacy and Zoom, right? And privacy and tracking for health purposes. So it's in the collective consciousness the way it never has been. And for that reason, I don't foresee it going away.
That's a great point. Maneesha, how about you?
I think it's very difficult to predict what Congress will do. But what I can say is that the Commission has recommended the enactment of federal privacy legislation to give the FTC additional tools. And I don't see that changing for the foreseeable future. But I agree with the other panelists that this is an issue that's here to stay.
Lee, final word.
Well, I think you never know what's going to happen in Congress. It depends a lot on how the elections go. It depends a lot on which party's in control, and then how bad the pandemic recovery is, because that's the most important thing for most of members of Congress is to make sure that the economy gets back on track, and I think that's going to be the focus for a long time. But I certainly agree that people will still talk about federal privacy legislation. There's certainly plenty of language that's been drifting around the Hill for the last couple of years. One of the things, though, that I think is going to make it especially daunting is I'm not sure how the pandemic specifically is going to impact how people think and talk about medical and health privacy legislation, right? Because one of the characteristics of virtually everything I've looked at on the field is a tendency to stick existing privacy laws into an exemptions kind of bucket. We did this in CCPA, right? It's like, yeah, HIPAA, it's exempt, GLB, et cetera, et cetera, et cetera. So what we had at the state level is a relatively comprehensive privacy law with a lot of carve-outs for federal privacy law. Now, if you're looking at federal privacy legislation, how much are people going to actually want to sort of reconfigure all of those existing laws with their existing sort of enforcement mechanisms? And I think up until now, every time I see a bill with like 7 exemptions for all those things, I go, okay, this is crafted in the short term. It's like we want to get something out, but you decided to punt on the interesting question of whether you were going to bring these other statutory regimes into the comprehensive privacy law. And I think before we might not have worried about the HIPAA side of it as much and automatically just said, yeah, we're just going to exempt HIPAA. But now between the pandemic, the changes with IoT devices, the growth of your Project Nightingale / Ascensions, all of these non-covered entity health privacy or health data collection, there is, and the pandemic, I think there's actually going to be a lot of space for thinking about, well, wait a minute, don't we have to fix that or do something about that? And I think that adds a level of complexity to the privacy legislation conversation we've been having. So right. I think it's going to be actually more complicated now.
Yeah, that's interesting. It's hard to believe it could be more complicated now than it has been previously. I want to thank all the panelists for all your time and really thoughtful input. It's been a fantastic panel, and I appreciate all your participation. Back to you, John.
Thanks, Chris. Gail, great discussion. Tell me, what were your takeaways from today's panel?
So like I said, big topic, right? This is a big area to cover. And then you layer on top of that the pandemic, and it leads to a pretty fascinating conversation. So I took away from the panel that there's at a meta level, there's change and continuity going on in real time here. And so I had 3 big takeaways that all sort of relate back to that meta theme of change and continuity. So the first takeaway is there was a lot going on with respect to privacy and the need for privacy legislation even before the pandemic. But the pandemic has indeed enhanced the need for privacy legislation. And it didn't seem to have changed the panel's position as to whether this is a needed thing or not. The real discussion and the meat of the conversation was around what would be in there, right? And how would we adapt and change to the privacy legislation to the present day, which of course has to take into account COVID-19. And as to the timing of the legislation, it seemed that folks agree there's probably not going to be something happening this year for all the reasons. Congress is otherwise preoccupied. But 2021, with a level set maybe in Congress and the White House, let's see how things shake out. We could be looking at a serious push around federal privacy. So change and continuity there. The second takeaway, so the FTC has had to adapt, and we heard this from Maneesha in particular in the past several weeks, to new privacy issues around how we live our lives now, right? And so by that, I mean, we're all at home, we're teleworking if we're adults, and thankfully we still have jobs. Our kids are, if we have kids, are doing their schoolwork online. And so this has given rise to new issues around newer technologies, such as video conferencing and ed tech for the kids and so on. And so the FTC is pivoting. They're looking at what to do with these new sets of technologies, but they're turning to their existing toolbox. And so that's where the continuity comes in. And so we heard Maneesha talk about the possibility of enforcement actions. And that's the time-tested way that the FTC tackles privacy concerns and data security issues too. And then we saw and heard about how the FTC is using this moment to educate consumers and businesses as to how to handle data in the era of COVID-19. And that was in particular with respect to the healthcare apps that we're all turning to. And then the takeaway number 3, I would say, and this relates back to the legislative push, is that the group seemed to agree that, and this is both change and continuity, but that we still need privacy legislation, and we can have privacy legislation and the benefits of big data at the same time. This is not a zero-sum game, and that's a debate that's been ongoing for some time. But of course, I think the COVID-19, the increased use of sensitive data and big data to fight the pandemic is giving a new edge to that debate. And one of the panelists, I think it was Jessica, made the smart suggestion that when we turn back to federal privacy legislation, once we're all back at our desks and so on, let's assume that this eventuality, this pandemic, could happen again, and let's pandemic-proof the legislation. Let's craft it as if it could happen again, and build in guardrails into federal privacy legislation for this moment. Not that we would want it to come to pass again. So those are the 3 takeaways for me.
Gail, again, I think what we have is an event that's putting into sort of sharp relief issues that have been lurking for some time.
I think that's fair to say. Yeah, continuity and change, and then a heightened sensitivity around privacy concerns in this era.
Well, so watch this space. I think there's much more to come. Thank you, Gail. Very, very helpful. Terrific analysis.
Thank you, John. It's been a real pleasure. And if you may indulge me for just 1 second, I wanted to give huge shout out to you, to Brian Henry, the section leadership, the staff for doing this. I mean, you guys, you've got lemons and you've made lemonade with this virtual spring meeting. So kudos to you all.
Thank you. Very kind. And we're devastated that the real spring meeting didn't happen, but are hopeful that we can make something for our members. And so thank you for that, Gail. I'd also like to thank Chris OLSEN and all of the panelists for their really hard work in putting this all together. And most importantly, I'd like to thank our members, our listeners. We appreciate you joining us and giving the virtual spring meeting a try. So until we speak again, please be well and be safe.
Thank you for listening to this Virtual Spring Meeting 2020 edition of Our Curious Amalgam. It is produced and shared around the globe by the American Bar Association Antitrust Law Section. The opinions expressed by the participants in the podcast are their own and do not necessarily represent those of their employer or other organization. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust Section has to offer at ambar.org/antitrust. If you have suggestions for topics or are interested in participating in a future episode, please reach out at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.